Good morning. My name is Anush Hakimi, and I am the CEO of TrawFunder.com, an online platform for investment and litigation finance. The presentation today is Litigation Finance 101. If you have any questions, please email your questions to info@TrawFunder.com, and we will address questions in the order they are received. Again, that's info@TrawFunder.com. Also, I encourage all viewers who have not yet created an account at TrawFunder.com to do so. A free account at www.trawfunder.com will give you access to all areas of the site and give you a fuller understanding of what actual litigation finance transactions look like. Now, to dive in. Litigation finance is one of the fastest growing asset classes for investors in the finance industry. The industry is growing at a breakneck speed and has grown by over 700% in the last 3 years. So the question is, why? The answer is simple: profits. Today, I will discuss the basics of the litigation finance industry in America and walk you through the typical types of litigation finance deals, the deal structures associated with these deals, and the typical profits for investors in each case. I will also discuss an incredible and revolutionary change that is taking place in the world of alternative litigation finance. What is that great change? We are seeing, for the first time in history, the marriage of technology and the litigation finance industry. Investments in litigation can be extremely profitable. The typical returns are over 100% for investors. In fact, every single investment our company has made has returned a profit to investors, and in each case, the returns have been above 90%. So, we're either really lucky, really good, or there's something else going on here. While I would like to take credit and say that we're both really lucky and really good, the truth is that there's something else going on here, and it's simple economics. Our success has resulted from the simplest application of supply and demand. There is a very, very high demand for capital in the litigation finance industry, and there is a short supply of capital, which means we and the other litigation financiers can cherry pick the top 1% of cases seeking funding. But that wasn't always the case. In fact, there wasn't even a litigation finance industry until relatively recently. And I'll get to the historic prohibitions of litigation finance in America in a minute, but let's start by first defining litigation finance. The simple definition of litigation finance is the act where a third party, unrelated to a lawsuit, provides money to a party involved in a lawsuit in exchange for a financial reward. There are dozens of different types of litigation finance structures, but today I will discuss the three most common types of litigation finance: consumer funding, litigation cost funding, and subprime law firm loans. The first is a type of litigation finance known as consumer funding. You may have seen the commercials on television or heard them on the radio, where a burly guy is hanging out of a window of his apartment and he yells, "It's my money and I need it now." In these situations, you have a plaintiff involved in a lawsuit, typically personal injury, who doesn't want to wait for a settlement or judgment in order to get paid. So they get a cash advance against their future recovery. The deal size in the typical consumer funding scenario is between $2,000 and $15,000. So consumer funding businesses rely on volume. The money is typically used by the plaintiff to pay for living expenses. Now, this is what a typical repayment schedule looks like on a $10,000 cash advance with an interest rate equal to 3.5% compounded monthly. As you can see, there are typically 6-month minimum payment intervals, which means, for example, that if the plaintiff pays at month 4, they pay through the 6th month. They pay on month 9, they pay through the 12th month, and so on and so forth. This accounts for the high IRRs that are associated with a consumer funding investment. Whereas the annualized rate on an investment that pays 3.5% compounded monthly is 51.1%, the annualized rate, taking into account the 6-month intervals, is typically in the 90% range. Now, let's take a look at how the litigation financier fares compared to an attorney with respect to the proceeds of a settlement. Let's assume the litigation funder makes a $10,000 advance, and the repayment amount after 12 months is about $15,000. In the first scenario, the case settles for $100,000. The attorney receives $35,000, which is 35% of the total recovery, and the litigation funder receives $15,000 from the $65,000 payable to the plaintiff, which is the contracted for rate. In the second scenario, let's assume the case settles for $30,000. The attorney only receives $10,500 in this case, which is 35% of the total recovery. However, the litigation funder still receives its full $15,000, which is the contracted for rate. So, despite the fact that the litigation funder is seemingly junior to the attorney in the capital stack, in actuality, it is in a more secure position because the attorney's bucket is tied to performance, but the litigation funder's bucket is not. This type of funding is probably the most lucrative form of litigation finance. Most funders target an above 100% annual return on their portfolios, and they are usually successful. Now, let's take a look at a couple of real-life transactions that we funded through TrawFunder and the results. There are more examples similar to these on the website, but these are a couple that are typical of what you can expect with this type of litigation finance. In the first instance, the plaintiff, Fatima Reed, was injured in a trip and fall accident. Her lawsuit claimed that the premises were not properly maintained, causing her to trip on an obstruction and get injured. We reviewed the evidence, including pictures of the premises, her medical records, which indicated she was a candidate for surgery, the legal filings to make sure everything was properly pled, and most importantly, the profile of the defendant. The defendant carried liability insurance, which covered this type of claim. So we knew that the plaintiff was highly likely to recover. She needed a cash advance of $2,000 to cover living expenses while she waited for her case to settle. If she didn't have the cash advance, it's highly likely that she would have succumbed to financial pressure and accepted a settlement for much lower than the value of her case. So we made a $2,000 cash advance to Ms. Reed at a rate of 3.5% compounded monthly, and then sold the position to investors through our platform, TrawFunder.com. Not surprisingly, her case settled 3 months after it was funded through our site and resulted in a 96.12% IRR for investors. The second example involves a 9/11 first responder. Mr. Nicholas Fornario was one of the brave first responders who arrived at the World Trade Center site shortly after the horrific terrorist attacks of 9/11. He was part of the ongoing and sustained cleanup effort. What wasn't clear to first responders was that they were breathing in toxic chemicals and debris throughout the cleanup process. 15 years later, Mr. Fornario, like many other first responders, was waiting for payment under the 9/11 Victim Compensation Fund created by the US government. Based on our due diligence, we were able to determine that his claim under the fund was highly likely to be successful. Mr. Fornario needed a $4,000 cash advance to cover his living expenses while he waited for a payout from the government under the Victim Compensation Fund. So we made a $4,000 cash advance to Mr. Fornario at a rate of 3.5% compounded monthly, and then sold the position to investors through our platform, trawfunder.com. Not surprisingly, Mr. Fornario's claim was approved and paid out under the Victim Compensation Fund 6 months after it was funded through our site, and resulted in a 98.49% IRR for investors. This type of litigation finance is not only incredibly lucrative for investors, it also satisfies a very important social good. For example, in the context of personal injury, the victim is typically left unable to work and provide financially for their family. Defense firms and insurance companies understand the financial pressures that personal injury plaintiffs suffer. So they prolong litigation and fight a war of attrition. The goal is to drag out the litigation to the point where the plaintiff becomes financially crippled and accepts a low-ball offer. However, a cash advance from a consumer funding company provides the plaintiff with sufficient capital to cover living expenses and hold out for a fair and reasonable settlement offer. This not only ensures justice for the individual, but also translates into a net benefit for society. If bad actor defendants are held accountable for their actions, then they are likely to reform the bad or negligent conduct, which means a safer society for all of us. It's a win for the plaintiff because they will be able to cover their living expenses while they pursue their rights. It's a win for investors who make high non-market correlated returns, and it's a win for society, as greater plaintiff enforcement of rights means a safer society. Now, the second type of litigation finance I'd like to discuss is litigation cost funding. In this scenario, the plaintiff is not looking for a cash advance to fund their living expenses. Rather, they are looking for capital to fund either the hard costs of litigation or pay their attorney fees, or both. So the question is, if attorneys take a matter on a contingency fee basis, why is this type of funding even necessary? The answer lies in limited resources. Every plaintiff contingency law firm has limited resources. A small law firm of 1 or 2 partners will typically have 30 or 40 active matters at a time. What this means is that as the litigation moves forward, the partners will have to front the hard costs of litigation, like expert witnesses, deposition fees, and this is for many cases at a time. This inevitably creates a liquidity issue for the firm. The firm is incentivized to pressure their clients to settle for less sooner rather than later in order to bring some cash into the firm's coffers and to keep the lights on. So with litigation finance, lawsuits can reach their full potential. In these types of deals, the plaintiff either agrees to pay back the investment amount plus a rate of interest similar to the consumer funding example, or the plaintiff may be required to pay back the initial investment amount plus a percentage of the total recovery. Now, let me give you an example of the opportunities available with respect to litigation cost funding. The very first offering we had on our platform was a police brutality case. The plaintiff needed $20,000 to pay for expert witnesses and other costs. We created a campaign and raised the $20,000 through accredited investors in just a few days. 9 months later, the case settled and our investors were paid $41,750. This translates into 147% IRR and 108.75% ROI. And there are literally thousands of opportunities like this in the litigation cost funding market a month. As a first online offering, the results were pretty good. An additional benefit was the social good component. The plaintiff, a 63-year-old man, was roughed up on camera by the police, causing a compression fracture to his T2 and T3 vertebrae. He didn't have the money to cover the cost of litigation, and he wouldn't have been able to properly pursue his lawsuit without litigation finance. So we felt pretty good about balancing the scales a little when it came to this plaintiff, as did our investors. The third type of litigation finance I'd like to discuss with you today is subprime loans to plaintiff law firms. This is a fast-growing form of litigation finance, whereas litigation funders make subprime loans to plaintiff law firms to fund the law firm's business. Since most plaintiff litigation is on a contingency fee basis, plaintiff law firms that are involved with large class action litigation usually run into liquidity pressures and use this type of finance to smooth out cash flows, keep the lights on. Structurally, it's fairly straightforward. The litigation funder makes a loan, either recourse or non-recourse, to the law firm and underwrites the balance sheet of the law firm based on the potential attorney fee recoveries of the firm in ongoing litigation. An interesting twist to this form of litigation finance that we have seen that is causing a great deal of growth in the litigation finance market and an evolution in the practice of law is the use of this type of funding as acquisition funding. Specifically, law firms will borrow money to acquire clients from other law firms. And this is typical in the class action and mass tort context. Now, to understand this, you have to understand the evolution of the business of the practice of law. Over the last 15 years, a new type of law firm has increasingly started to pop up across America. And these can more effectively be described as marketing and business development law firms, rather than law firms where people actually practice law. These firms spend all of their time and resources marketing, whether through TV, radio, or the internet, to sign up clients with a particular type of litigation, rather than actually working on cases. They then sell the leads to law firms that have the litigation chops to actually litigate. The buying law firms use acquisition finance secured by the fees in the client's lawsuits they are acquiring to acquire the clients. As the size and complexity of mass tort multi-district litigation has grown, the use of this type of finance has grown. And we anticipate that this type of litigation finance will likely be one of the fastest growing areas of litigation finance. The cost of this capital to law firms is typically between 8 and 25% compounded annually. So I started this webinar by alluding to historic prohibitions on litigation finance in America. Litigation finance is now fully legal. But one of the main reasons that the industry's growth was stunted for so long was arcane common law prohibitions that make no sense in the current American context. Litigation finance was historically prohibited by the common law doctrines of maintenance and champerty. Maintenance is a broad category and refers to when a third party, unrelated to a lawsuit, provides support of any kind to a party involved in a lawsuit. Champerty is a type of maintenance and is a narrower category that refers specifically to when a third party, unrelated to a lawsuit, provides financial support to a party involved in a lawsuit. These doctrines carried over from English common law, which is the legal system from which our American legal system is derived. These doctrines were formulated in medieval times, where feudal landlords would finance and otherwise support lawsuits by their subjects and tenants against other feudal landlords and wealthy landowners. So it appears there was a problem in medieval England with wealthy landlords using the court system to settle personal scores. Luckily, as American courts and legislators realize that we don't have the same problem of predatory landlords here in the US, we see most US states eliminating these doctrines. And this happened really over the last 30 years. The litigation finance industry, due to these legal prohibitions, didn't really have legs to grow until the last quarter of a century. And it's really in the early 90s where we see a litigation finance industry start to form and slowly grow. The litigation finance industry has been growing steadily over the last 25 years, but the growth of the industry over the last few years has been exponential. So I'm often asked by attorneys if litigation finance is in fact ethical. My answer is quite simply that it is, if done properly. The primary ethical considerations that attorneys and investors should pay close attention to when working with any litigation finance company involve A, the funder's interference with the attorney-client privilege, waiver of the attorney-client privilege, and issues of attorney fee sharing. A core principle of an attorney's professional responsibility is an undivided duty of loyalty to his client. The attorney must not allow the interference of other parties or interests with his exercise of independent judgment in the representation of his client. Many litigation finance companies will require approval rights with respect to litigation strategy and settlement decision making, which compromises the attorney's ethical duty to his client. Being attorneys ourselves, at trialfunder.com, we are very familiar with the ethical rules and do not interfere in any way with an attorney's trial strategy or settlement decision making. We only accept meritorious cases from highly accomplished attorneys with proven track records, and therefore rely on the attorney's good judgment in faithfully and effectively prosecuting the action. Another cornerstone of the legal profession is the confidentiality of attorney-client communications and attorney work product. Care must be taken when dealing with a litigation funder to follow a certain protocol to ensure that there is no waiver of confidentiality. Specifically, the courts have held that so long as the confidential information is provided under a non-disclosure agreement, it is not discoverable by the opposition. At trialfunder.com, we will not request any confidential information from the attorney until a non-disclosure agreement is in place. Our method is to first review publicly filed documents, which are not confidential by their very nature, and if there's an interest in moving forward, to execute a non-disclosure agreement and proceed. Attorneys are prohibited from sharing fees with non-lawyers. This rule is derived from the principle that attorneys should maintain their independent professional judgment and do so by not entering into financial arrangements with non-attorneys who may influence the attorney's decision-making. Other than subprime loans to plaintiff law firms, most litigation finance transactions are structured as direct deals with the plaintiff, thereby avoiding the issue of attorney fee sharing. At TrawFunder.com, we enter into a direct agreement with the plaintiff wherein we agree to either make a cash advance to the plaintiff for the plaintiff's living expenses or refinance the plaintiff's legal costs and fees. This type of structure has been explicitly approved by many states and local bar associations and does not implicate the attorney fee sharing prohibitions. Now that we've covered the profitability of litigation finance and the ethical considerations of participation in litigation finance, I'm going to discuss with you how to underwrite lawsuits for investment and how we underwrite lawsuits for investment. First, liability. Liability as a legal concept is defined as the legal responsibility for one's acts or omissions. This is a legal question and requires an understanding of the applicable law and the applicable legal standard. Let me give you an example. In California, if you are attacked by someone's dog and the dog bites you, the standard of liability is strict liability, which means that the owner of the dog is liable, even if the dog has historically been the friendliest dog ever and has never bitten anyone before. The legal standard for establishing liability varies according to the type of lawsuit. Let me give you another example. Let's say Sally is driving down the street and she is rear-ended by Mark. In order to establish that Mark is liable, in other words, legally responsible for his actions, Sally has to show that Mark was negligent. The legal standard for liability in automobile cases, and typically most personal injury claims, is negligence. Negligence is basically a failure to use reasonable care when doing something. Next, in underwriting claims, we look at damages. Damages as a legal concept is the amount of money owed to a plaintiff in a lawsuit. There are many types of damages that may be awarded in a lawsuit. Special, general, exemplary, punitive. It is typical for legal funders to spend most of their time underwriting a lawsuit on the damages question. Third, we look at the defendant's ability to pay. We will not finance a lawsuit unless there is a defendant that we determine has a very real and tangible ability to pay at the end of the day. Individuals usually do not make great defendants unless they have insurance. A defendant, either an individual or business, with insurance is a great defendant. Fourth, we look at the timeline to recovery. The amount that is required to be paid back by the plaintiff increases over time. So what you want to do is make sure that the amount of the projected total recovery is greater than the amount of your investment plus any interest earned on your investment during the term of the investment. So in order to correctly determine this amount, we look at historical data and comparables based on the type of lawsuit and the jurisdiction to determine the timeline to recovery. Finally, since the plaintiff attorneys are the champions of our investment and are going to be shepherding the litigation to a successful outcome, we underwrite the prosecuting attorney and law firm. We look at their track record and their experience to make sure that the litigation is in the right hands and therefore investable. So what do we do here at trialfunder.com? In short, we give investors access to litigation finance investment opportunities. So an investor can now log on to trialfunder.com and invest in litigation finance all securely and seamlessly from the comfort of their own home. Being attorneys and being involved in litigation finance, we knew the high returns available to investors, but we noticed a huge problem, which was that there was no access to the booming and profitable litigation finance industry for non-institutional investors. Let's face it, most investors have never heard of nor had access to investing in litigation. It has historically been an exclusive club for attorneys and hedge funds with connections. Even if an investor finds himself in the unlikely scenario of having the opportunity to invest in litigation, how in the world does he value the investment? So there's a huge underwriting challenge. Will the case result in a high return, or will I lose my investment? This is a reasonable question for an uninformed investor. Finally, high minimum buy-ins for hedge funds that trade in litigation keep most investors out and have historically limited the benefits of this asset class to institutional investors. So we noticed this huge problem in the litigation finance industry, and we came up with a technology solution, which is trialfunder.com. At trialfunder.com, we connect investors to highly lucrative litigation finance investment opportunities online. We provide access, which means investors don't need to personally know plaintiffs or plaintiff attorneys or hedge fund managers. And what about underwriting the cases? All of the investment opportunities on our platform have been vetted by numerous attorneys and legal professionals. We do the heavy lifting so that investors can simply go online and invest. And probably best of all, investors don't have to bet the kids' college tuition while they're exploring the exciting world of litigation finance. The minimum investment for most deals on our platform is currently around $50. We can do this because we have automated the investment process through proprietary technology. Will the minimum buy-ins always be this low? Probably not. But for the meantime, while we educate the investing public regarding this amazing asset class, we will keep the minimum investments low. And we'll raise the minimums only after the investing public is totally comfortable with this asset class. So one of the questions that we receive often has to do with the selection process, and in actuality, how selective we are when determining whether a lawsuit is a suitable investment. As I mentioned earlier, due to the fact that there is a very high demand for capital among plaintiffs in the litigation finance industry, we can be highly selective. Our team goes through a high volume of cases every week and selects the strongest cases. The process is actually quite simple. First, the plaintiff or attorney seeking funding reaches out to trial funder. We have trained case managers that will field this initial submission and go through one of various checklists that we have developed based on the type of lawsuit. Each lawsuit is then given a numbered rating based on the factors checked off the checklist. Most submissions do not pass this point. If the case meets the high minimum threshold, then it goes to a trained attorney or underwriter who conducts an initial review to determine if the lawsuit is a good investment based on comparables and other substantive factors. More than 50% of cases do not survive this step. Next, we will conduct in-depth due diligence based on the underwriting elements that we discussed earlier. Finally, for the lawsuits that make it to the final step, our investment committee will vote on each lawsuit, and if approved by a unanimous vote, we will then collect the plaintiff's executed paperwork and fund the plaintiff. Why is it important for us to spend so much time and effort underwriting cases? It's simple. We don't make a dime unless investors make a profit. Unlike funds and money managers, we do not collect a penny to manage money. We only make money when investors make money. That's how it's always been, and that's how it always will be. So most investors want to know what they are buying exactly when they invest at trialfunder.com. To date, we have only offered investments in single lawsuits, but in less than 2 weeks, we will be introducing the diversified multi-lawsuit fund model. First, I will discuss the single lawsuit investment model, and then I will discuss the diversified multi-lawsuit fund model. Under the single lawsuit investment model, there are 2 steps. In the first step, we set up a single purpose LLC for the sole purpose of pre-funding a plaintiff that has been approved for investment by our investment committee. Then that LLC pre-funds the plaintiff and enters into a contract with the plaintiff, wherein the plaintiff agrees to repay the LLC the initial investment amount pursuant to a repayment schedule, like the one we looked at earlier. In the next step, we sell 100% of the ownership interests in that LLC to trial funder investors through trialfunder.com. As I mentioned a few minutes ago, to date we have only offered the single lawsuit investment model. Since the date of our launch, we have heard one common theme from the investors on our site. The customers have spoken and we have listened. We will soon be offering investments in diversified funds that will invest in multiple lawsuits. Our first diversified fund, which is going live in less than 2 weeks, is a diversified personal injury fund. This means that once the campaign goal is met, then the fund will invest in multiple personal injury lawsuits that fit within a certain strict investment criteria. So how does this work, and what is the investor actually buying? It's actually quite simple. Under the diversified multi-lawsuit fund model, there are 2 steps. In the first step, we set up a single purpose LLC that we will call from now on the fund, for the sole purpose of investing the money contributed to the fund by investors in multiple lawsuits that satisfy certain strict investment criteria. Then we sell 100% of the ownership interest in that LLC, the fund, to trial funder investors through trialfunder.com. The investors essentially become the passive owners of the fund. In the next step, the fund, applying the strict investment criteria that it is bound by, will then invest in multiple lawsuits. In each case, the fund will make a cash advance to a plaintiff, and the plaintiff will enter into a contract wherein the plaintiff agrees to repay the fund according to a repayment schedule, similar to the one you saw earlier in this webinar. The objective is clearly to have a diversified portfolio and spread the risk across multiple lawsuits rather than to invest in just one lawsuit. So that's a little bit about our company and how we give investors access to the highly profitable world of litigation finance. But now, a quick word about litigation finance in general before we move on to Q&A. Litigation finance promises to have huge benefits for our society with respect to our justice system. We can expect that drug companies will be more responsible, that employers will treat their employees fairly, that our food, air, and water will be clean and not poisoned, that breaches of contract will be remedied, and that theft of intellectual property will be deterred. These are only a few of the examples of the social benefits that will come as litigation finance grows as an industry. This is an industry that is in its infancy and holds a great deal of promise for investors and the consumers of capital. Free markets do work, and what comes next is the beginning of the evolution of a more efficient and effective justice system. Now to Q&A. As I mentioned earlier, we will go through questions posed by viewers in the order they are received. If you have not yet submitted a question, please do so by emailing us at info@trialfunder.com, and if time permits, we will answer it during this webinar. Okay. The first question: how do you control cash and make sure that the plaintiff pays when a case is settled? That's actually a great question. So every time we make a cash advance to a plaintiff, as part of that contract that we enter into with the plaintiff, there is an attorney acknowledgement section that has to be executed by the attorney representing the plaintiff. The attorney acknowledgement section does a couple of things, but most importantly, the attorney acknowledges that the trial funder entity has a lien on the plaintiff's recovery. And the attorney also agrees to first pay off the lien of the trial funder entity before making any payments to the plaintiff. Attorneys are required by legal ethical standards to make payments of all third-party liens that they are aware of. Failure to do so subjects the attorney to discipline by the applicable state bar, which may include potential disbarment. And since the proceeds of a settlement or a recovery always go to the plaintiff attorney and not directly to the plaintiff, it's a secure system of making sure that the trial funder entity's lien is paid off. Just as a side note, this isn't we didn't come up with this method of doing business. Other consumer funding companies have been doing it for a very long time, and it's been a tried and tested method that has worked. Okay, moving on to the next question. Are these investments subject to usury laws? That's another great question. The short answer is no. Now, I guess the question is why not? Usury is a principle that applies to debt obligations. These investments are, by their terms, they're non-recourse, which means that the plaintiff is only required to pay if and when there is a successful recovery. So if there's no recovery, the plaintiff is not required to pay back the cash advance or an investment in his or her case. So from a legal standpoint, since there's no absolute debt type obligation at the time the advance is made to the plaintiff, these investments are not regulated like debt. So they're not subject to usury laws. Okay, moving on. Okay, the next question. Why are investments on trialfunder.com limited to accredited investors? Okay, I'm going to attempt to keep this one short, but it's really a long answer to this. So in 2012, Congress passed the Jobs Act, which does a few things and has multiple elements to it. One of those elements is under Title II of the Jobs Act, which basically removes some prohibitions on solicitation of investors for non-registered securities. Each offering on the TrawFunder platform is a Reg D private offering. So the securities, the LLC interests, are not registered securities, like security would be on a well-known exchange like the NASDAQ or the New York Stock Exchange. The private offering market, based on filings with the SEC, is actually a huge market, and it's estimated to be a $1 trillion annual market. And this is based on filings with the SEC. Before the passage of the Jobs Act, investors could only invest in these types of offerings if they had a pre-existing relationship with the issuer of the securities and had access to the offering. In other words, if you were the issuer of the LLC interests, you could not advertise the sale of the LLC interest. Just to be clear, advertising is synonymous with general solicitation, which is the actual phrase that has been used in the words of the legislation and is used by the SEC. So this basically meant that if you were the issuer of non-registered securities like the LLC interests sold on TrawFunder, you worked within your network or with intermediaries who charge high fees and had relationships with issuers. The Jobs Act, under Title II, very importantly, removed the ban on general solicitation, which opened up the private offering market to investors to gain direct access to these types of investments and forego the intermediaries that charge the high fees. The caveat that came with this lifting of the ban is that these investments are then limited to investors who are more sophisticated and financially suitable. In other words, they're limited to accredited investors, which is a specifically defined category under SEC rules. Our platform is one of many that takes advantage of this deregulation to offer investment opportunities directly to investors online. There are many other platforms that do the same thing for different types of assets like real estate and venture capital investing. We do it specifically with respect to litigation finance. So now we are limited to accredited investors, but that won't always be the case. About 90 days ago or so, the SEC published final rules on Title III of the Jobs Act. Title III allows the sale of these types of securities to non-accredited investors, basically Main Street investors. We have built a separate platform that will accommodate this type of sale, because you can't do both types of offerings on one platform. You can't sell to accredited and non-accredited investors on the same platform. So we've built a separate platform specifically for non-accredited investors. But some of the regulatory guidelines and the execution of trades is still a little unclear. So we are waiting to see how other platforms deal with these issues before we dive right in. With that said, we anticipate that we will launch the non-accredited platform before the end of the year and open up this asset class to all investors. So unfortunately, it appears that that's all the time that we have for today. If you have any additional questions, please feel free to email us at info@trawfunder.com, and we will provide a response promptly. I again encourage you to create a free account at www.trawfunder.com in order to be able to access all pages of the site. Also, registered users of the site receive advance notice of all new investment opportunities, and the opportunities on our site generally sell out very quickly. So if you are interested in investing, the first step is to create a free account and you'll be ahead of the curve. Thank you for joining us today.